today in this video I will discuss about the doctrine of colourable legislation in Indian Constitution. I have divided this doctrine of colourable legislation into 5 subheads for your better understanding. So, let us start. So, what is doctrine of colourable legislation? So, in about we can say doctrine is also known as fraud on constitution. So, this doctrine is also known as fraud on constitution. The doctrine of colourable legislation comes into play when a legislature does not possess the power to make a law on a particular subject, but nonetheless indirectly makes one. So, it means when the legislature does not possess the power to make a law upon a particular subject, it makes it indirectly. So, by applying this principle, means by applying this colourable legislation, the fate of a in-punch legislation is also decided. Now, we come to the origin portion. So, from where it originated, the doctrine traces its origin to a Latin maxim. So, we can find that the doctrine has its trace from a Latin maxim, which in this context implies that what legislature cannot do directly, it can do it indirectly. Means if anybody cannot do anything directly, then he will not be allowed to do that indirectly. So, now we come to the next subhead. The next subhead is that constitutional provision. So, the doctrine is usually applied to Article 246 of Indian Constitution, which has demarcated the legislative competency of Parliament and the state legislative assemblies by outlining the different subjects under the union list, state list and concurrent list. Now, the next subhead is that limitations. In limitations, we can say the doctrine has no application where the power of legislature are not fettered by any constitutional limitation. It is also not applicable in subordinate legislations. Now, if we come to the last subhead, that is important judgment. One of the important judgment is that KC Gajapati versus State of Odisha case. In this case, Supreme Court has applied this doctrine of colourable legislation. The doctrine implies that whatever is prohibited directly is prohibited indirectly also. This is the intended to bar legislature from doing something indirectly or covertly that has been prohibited from doing indirectly. So, this has been held in this case by Supreme Court. Hope you all have liked this video. If you like this video, then please subscribe my channel and also share it with your friend. That's all for today. In the next class, I will again discuss about another doctrine.